Ladies and gentlemen, thank you for standing by. Welcome to the Role of Information Governance in Legal Hold and Preservation webinar Part 2. During the presentation, all participants will be in a listen-only mode. If you would like to ask a question during the presentation, please use the chat feature located in the lower left corner of your screen. If you need to reach an operator at any time, please press *0. As a reminder, this conference is being recorded Thursday, August 29th, 2013. I would now like to turn the conference over to Robin Thompson. Please go ahead.
Hi, everyone. This is Robin Thompson, and on behalf of the team here at BIA, we'd like to welcome you to Part 2 of our discussion of the role of information governance in legal hold, where our experts will go into a little more depth about triggers and implementation. Before I introduce our two speakers, I'd like to remind you to submit any questions for our speakers through the chat window and ask your help in answering the short survey you'll be prompted to take as you exit today's program. Now, my favorite part of today is introducing our two speakers. John Azaza heads the Information Management Practice Group of Memo. He is internationally recognized in the emerging legal fields of information governance, as well as records and information management. He is one of the country's foremost experts on RIM issues, electronic discovery, and legal holds. John is a favorite speaker and prolific author, and in fact is the author of one of my favorite personal library books, The 7 Steps of Legal Hold of ESI and Other Documents, which you can receive at a 10% discount today as a Knowledge Leadership webinar attendee by writing John directly or writing education@biaprotect.com. Our other speaker today is Alon Israely. He leads the Strategic Business Partnerships at BIA. As a licensed attorney and IT professional, he brings a unique perspective to programs that have made him one of the most sought-after speakers in his field. For more than 15 years, Alon has worked with corporations and law firms to address management, identification, gathering, and handling of data involved in litigation of all types. In addition to being an attorney and IT professional, he holds the distinguishment of being a certified information systems security professional. And with that, I turn the presentation over to you, Alon.
Thank you, Robin, and thank you, everybody, for joining us today. What we thought to do is, since this is part 2 of a series, if you see here today's agenda, what we'll do is going to quickly recap part 1. We're not going to spend too much time on it. And then we're going to have John talk about what triggers a legal hold, which is very important, as well as do some discussions around the new proposed Federal Rules of Civil Procedure. And then I'm going to talk about what you actually need to do to implement a hold inside your organization. So with that, we'll start. I know that John has to leave a little early today. He's got go talk to some clients, has a client meeting where he's actually going to be talking about some of this stuff. And it's nice to know that that both he and I are practitioners. So nice part of this is that you're getting to listen to this webinar, and you should know that we're not just webinar junkies, but we actually do this stuff in real life as well. So he's going to leave us a little early, and so any questions you have that maybe pertain more to his subject matter, you can either email him directly or you can email the education@biaprotect.com, and we'll make sure to get you an answer around those. So with that, I'll start. And really, I want to kind of just make sure we're all on the same page here and make sure we're speaking the same language. This is a little bit sorry about that, little technical difficulty there. So what does it mean to be on the same page? Let's talk the same language. And if you're looking at the screen, you see this is the EDRM. If some of you are familiar with this, the industry standard model. It really kind of takes you through the steps of litigation. And so here we see that most of everything that happens with respect to legal holds and preservation happens on this left side of the EDRM, or kind of in the most of this side of it, which is everything that happens inside the corporate domain, so to speak. And primarily, the information governance professionals are responsible for a lot of this stuff. Now, I won't go into too much detail because we did in the first webinar, but the important points to note here are that the organization owns the legal hold and the preservation side of this process. And the attorneys, your outside counsel, they own the rest of it. Once the data has been preserved, once people have been put on hold, once the data has been placed on hold and it gets transferred to the attorneys, that's where they do their thing. But what we're going to be focused on today is everything that happens inside of the organization. So let's talk a little bit about language. As attorneys, language is very important. We like to define things. So custodian is a term that we use in the legal sphere, but really for an IT guy that may mean user, for a RIM or a manager that may mean employee. Legal hold is the notification of users plus the preservation of data. And that's an important point, which is a lot of times we think of legal hold as just the notification side of things, but really it's bifurcated, and it's not only the notification, but it's also the actual gathering or locking down or preserving of data. And we'll talk a little bit about more how that happens in the implementation side of things. And then, of course, data or documents or ESI. ESI is the Federal Rules of Civil Procedure term for essentially for data and documents. It's electronically stored information. And then for the RIM folks, it's possible records. Obviously, records has their own definition, but any of the data that you may be preserving may possibly be an actual corporate record besides just a normal document. And then, of course, data collections is just the term we use in order to secure the data or gather it or ensure that you have a copy that can't be deleted or can't be altered, which goes directly to that notion of preserving data. So preservation really is what happens on CorpNet, and that's kind of what I said a little earlier with that EDRM slide. It's notifying people, identifying and gathering stuff, and ensuring that all of those automatic tasks that happen in the background in systems are either suspended or at least the corporation is aware that they're happening, and steps are taken to ensure that those automated tasks are not breaching any of the preservation duties or not altering or deleting any data. So the preservation is a required legal duty, and that's very important to this, is that the rules specify that you do have to preserve documents. It's not okay to get into a legal situation or a legal matter or litigation and not have some affirmative activity around preserving data, ensuring that you have it for the course of the case. That's really a key point there. And then just kind of summarize here, you have four main areas of that preservation or of doing kind of legal holds, which is notifying people, ensuring that you're identifying the right data in the right systems, otherwise known as data mapping, at least from a discovery perspective. Then, of course, IT task management, make sure those tasks are suspended that are going to delete or alter data to the extent you can. We'll talk about what the steps you have to take and the standard under which we work for that. And then ensuring that the data is gathered or preserved physically such that it can't be altered. So with that, that's kind of a recap of the first session, or at least some parts of the first session. And I think that's important because I want to make sure everybody's on the same page, and we are talking about all of that stuff that happens inside of the corporate domain with respect to ensuring that data and documents are not deleted and not altered, so that you're in a position to certify that in court later on, especially if you're asked questions or you're pushed around some of these things. You can take a very strong stance and say, here's what we've done and what we continue to do. In fact, one of the things we'll talk about is consistency. It's very important in this process that you're doing the same thing with every case you have. So with that, I'll turn it over to John, who's going to talk. We're going to do a deep dive into two main areas.
Okay, great. So as Alon pointed out, later on we're going to be talking about basically the implementation of the hold, which is what he's going to walk you through in fine detail. But the focus of my area of the presentation today is on determining what these triggering events are and basically analyzing that duty to preserve. And the reason I'm going into this is because towards the end of my little segment of the presentation here, we're going to be discussing some proposed amendments to the Federal Rules of Civil Procedure regarding Rule 37, which address this issue of triggering events indirectly. There will be a lot more chatter about this. They were just the Rule 37 and other proposed amendments to the federal rules just came out a couple of weeks ago, and they're open for commentary until February of this year. So there's still plenty of opportunity for us to make a mark on it. So let's talk about what triggers a legal hold. And this cartoon is really very funny because you're right, anticipating litigation is really what it's all about, and it really is like looking into a crystal ball. So what are considered triggering events? That is the most important thing for you as an organization to determine. So a triggering event for issuing a legal hold, or in other words, engaging Alon and his company or anybody else within your organization to issue your legal holds, really comes down to the foreseeability of whether the litigation is likely to occur. So it's not just simply when litigation is pending. In other words, when you've been served with a complaint and you know what the allegations are against you, or when you've been served with an order from the court. It's actually way before that, in anticipation of when things could go down, and it applies to both you as a defendant, in other words, you kind of anticipating that you could be sued, or equally to you as a plaintiff, anticipating that you are going to be filing some lawsuits. So we're going to do a deep dive into some of these cases, and we're going to talk about this concept of credible probability, which I've been latching onto several cases that we're going to talk about dealing with this concept of credible probability, which to me is a higher standard than simply reasonably foreseeable. So we'll be talking about some sample scenarios of foreseeability, and then I'll end my little segment of the presentation with the federal rule amendments, or proposed amendments. So what is foreseeable litigation? Back in 1994, even before these revised federal rules, of course, courts have been grappling with this issue of anticipated litigation for hundreds of years, believe it or not, pretty much since the beginning of the legal system. And what I liked about this Iowa Ham-Canning case is that it really says that it's not just potential. In other words, if you're an automobile manufacturer and you roll a vehicle on the road, of course there's always going to be a potential that you could be sued, but actual contemplation or anticipation. So I liked that they were trying to make the standard even more clear as opposed to simply looking into a crystal ball. Since that time, the Sedona Conference Working Group on Electronic Document Retention and Production, the site is right there, cited in the Spanish Peaks Lodge case, the courts have really actually started to embrace the concept that anticipation of litigation actually arises when you're on notice of a credible probability that it will become involved in litigation, okay? Credible probability to me is, again, a higher standard than just simply reasonably foreseeable. This standard has been adopted in Suazo versus Linden Plaza Associates case, which is a 2013 case, and Ware versus Atlantic Towers Apartment Corporation, also a 2013 case. So both of those cases are cited there. You will have access to these handouts in case you want to delve deeper into these cases, and unfortunately time will not allow me to go too deep into them today. So with all that being said, what do we consider to be reasonably foreseeable litigation, or probable litigation as the credibly probable litigation? So when it comes to reasonable foreseeability, here's a couple of cases that I've been talking about for years that really kind of illustrate the basic tenet of what is foreseeability. So in Blinzler versus Marriott International, what happened was a gentleman had a heart attack in his hotel room, and he called the operator of the hotel saying, hey, please call an ambulance right away, because from a hotel you can't call 911 directly. And this was back in 1996, before cell phones were as prevalent as they are now. And the hotel operator apparently for some reason waited like 15 minutes to call the ambulance showed up eventually, and by then Mr. Blinzler had passed away. So his wife sued for negligence, and during discovery, she wanted to get from Marriott International copies of the PBX records that showed that timeline, that critical timeline between when the operator received the call and when she finally called 911. And by then, Marriott had already destroyed those records. So the court held that in this instance, there was a spoliation inference. In other words, they assumed that Marriott destroyed it on purpose, even if they hadn't, just by virtue of the fact that they should have known that the fact that a heart attack occurred in one of their hotel rooms was likely to give rise to future litigation. The Acciona versus United States cases is quite the opposite. In that instance, the court held that there was no spoliation on behalf of the United States because the United States didn't foresee that someone could break into their facilities and steal a grenade, and from that grenade, then somebody goes out and actually throws the grenade. Somebody gets hit in Hawaii, and what the court basically said, look, the United States had a records retention schedule that said they are allowed to destroy records that pertain to their inventory. That should be enough to defend themselves, particularly in light of the fact that when the grenade was stolen, there's no way that they could have foreseen that somebody would have stolen it and actually deployed it somewhere that would injure people. So again, it goes to show you that a records retention schedule really is your first line of defense. And at the same time, if you're not anticipating litigation, like somebody coming in and stealing things from you, you're not going to anticipate that would result in injury to others. In addition to kind of the general element of foreseeability, there's what I call institutional notice. In other words, is there so much going on within the organization that you should start suspecting that it's just a matter of time before you get sued? And this, in this Louis versus Remington Arms case, what happened was that the Louis' son had been in the basement playing with the parent's gun. The gun went off, went through the basement into the first floor, and injured Mrs. Louis, if I recall correctly. And of course, the Louis sued Remington Arms, saying that the safety latch on the gun was not activated, and that's why it went off, and that's how Mrs. Louis wound up being injured and killed. The court here said that when discovery happened in this case, the Louis wanted to see evidence of any sort of complaints that have occurred against this Remington Arms Company, and the court said, look, there had been enough complaints in this case about the safety latch in that gun that the records that pertain to the safety latch of that gun would have been relevant. And not only that, but the frequency of those complaints and the magnitude of the complaints led to anticipated litigation. So that's an example of how a related lawsuit or related things occurring within your organization could be considered potential litigation or credibly probable litigation. But on the other hand, and this is just to just muddy the waters here and indulge me for a quick second here, in Texas, the state of Texas versus city of Frisco, and this is really the only case that I'm aware of, the court in Texas basically said, you know what, we're not going to go down that road. We're not going to go down this road of trying to be armchair quarterbacking and trying to figure out whether you should have known that you were going to be sued or not. To us, the fact that, I don't know what happened here, but there you see my mug. Technical difficulty here. Okay, there we go. So the court said that just, look, we're not in a position, just because somebody had issued a preservation letter to you doesn't mean that it resulted in a triggering event. I disagree with this opinion. Many other cases since 2008 have disagreed with this opinion, but I'm only bringing this case to your attention to show you how subjective it can be for the courts when they're looking in hindsight as to whether or not they will consider something to be a triggering event. Another type of triggering event is if you give notice to your insurance carrier. So in this case, Phoenix 4 versus Strategic Resources Corporation, I'm not going to go too much into the details of this case because it is rather complex, but suffice it to say that the investment company sued its investment advisors, and during the process, when the complaint was filed in May of 2005, by April of 2004, a year before, Strategic Resources Corporation had given notice to its insurance company that a dispute existed. That notice alone, which was a year, well over a year before the lawsuit was filed, the complaint was filed, that notice alone to the insurance carrier was deemed to be considered credibly probable litigation and obviously evidence of probable litigation because Strategic Resources Corporation basically notified its insurance carrier that it was coming down. I'll skip the rest of this. It's just basically that the rest of these slides go into a little bit more detail about what happened in the case. But I will kind of end that Phoenix case by telling you that the court was just outraged. They basically said that their indifference to the fact that things needed to be put on hold constituted an act of gross negligence that is not excused by the disarray of their business affairs. So they claimed, hey, look, we were in the middle of moving. When we were moving, we left some stuff behind, and we left it with the landlord, and the landlord threw it away. Nothing. That's not an excuse. The court just said that's just gross negligence in the way you handled those files. And your obligation is not confined to a request for documents. Your obligation is to search for the sources of those information. So simply paying lip service to a legal hold doesn't do enough. You actually have to get out there and be actively involved in trying to find documents. Next couple of kind of examples of triggering events were discussed during the first part of this series, so I won't go into too much detail, but in Zubulake, if you file a claim with an administrative agency, that is considered to be actually one of the most credible or credibly probable, really, likelihoods that you're going to be sued. So if somebody files a claim with an administrative agency, even though it's not a lawsuit, that can be considered credibly probable litigation. Similarly, as I mentioned in the previous presentation, in Zubulake, there were water cooler discussions. Basically, everybody within the organization suspected that it was just a matter of time before Mrs. Zubulake sued. So that, again, is an example of probable litigation. Another type of credibly probable litigation is if the plaintiff has been having conversations with his supervisor. So in Broccoli versus Eckerstar, it was an employment discrimination case similar to the Zubulake case, and he told two of his supervisors at Eckerstar, both verbally and email, that he was being sexually harassed. Kind of interesting that he was being sexually harassed, but I guess that could happen, right? He made numerous complaints to them about the inappropriate behavior throughout 2001, and then his supervisors then related verbally and via email to their superiors at Eckerstar, okay? Basically, the court granted Mr. Broccoli's motions for sanctions and included an adverse inference of spoliation evidence in the jury instructions. Because what happened was Mr. Broccoli sought copies of those emails and all that stuff, all those discussions that took place, proof that he had been talking to them about his harassment, and all of a sudden all this stuff had disappeared. None of these emails were around, and the court just was outraged. And an adverse inference instruction is where you basically tell the jury, ladies and gentlemen of the jury, you're allowed to assume that the absence of these documents means that they were going to be harmful to the person that can't produce them. So in this instance, defendants. the court said the evidence of a policy at EchoStar of what they call deep-sixing nettlesome documents or records and of management's efforts to avoid their creation in the first instance was overwhelming. Another type of triggering event is where you go out and you retain an expert to work on your case. So in this instance, in the Silvestri case, Mr. Silvestri went out and he was in an accident. Sorry about the noise in the background. Some cars going wild here. I guess it's a car against a motorcycle. Anyway, so he sued General Motors because the airbag didn't deploy appropriately. And when that happened, he somehow or other, between changing attorneys, destroyed the vehicle, allowed the vehicle to be destroyed. And this resulted in the ultimate sanction, which was the case against Mr. Silvestri, by Mr. Silvestri, was dismissed because there was no body for the General Motors to investigate and really study the vehicle and find out if it really was the airbag their fault that the airbag failed to deploy. I won't go into too much detail, but I do want to point out that this Silvestri case is an illustration of what happens when you are a plaintiff in a case. And similarly, in these Rambis decisions, which we talked about in Part 1, these were all mostly instances where Rambis got together and developed a strategy for suing companies that were infringing on their patents. So in doing so, they were getting themselves battle ready. And in getting themselves battle ready, they created a robust records management program and at the same time had a target and a hit list of all the companies that they were planning to sue. Well, in most of the jurisdictions, except in the Northern District of California, the courts held that that was considered spoliation because they should have known at the time that they came up with a list of who their opponents were going to be that this was going to be anticipated litigation. So that's another instance where you're the plaintiff and you need to be preserving records. I'm also pointing out this Micron Technology versus Rambis case because 10 years later, those shred days that they had at Rambis were still continuing to dog them, and additional spoliation sanctions were coming up in other cases. So now what I'd like to do is spend the last 3 minutes of my presentation walking you through the proposed federal rule of Civil Procedure 37, which deals with failure to make disclosures or to cooperate in discovery sanctions. So when it comes to this issue of failure to preserve discoverable information, the court is basically saying that if you fail to preserve discoverable information, or in other words, if you ignore all the red flags that I just pointed out to you as far as anticipated events and that kind of thing, whether or not it's notice from opposing counsel that they're thinking about suing you, or conversations with supervisors, or water cooler discussions, or any of those types of triggering events, the court is saying that if you fail to preserve that information, the court may impose sanctions against you, but only if the court finds that your actions were causing substantial prejudice and were willful or in bad faith. So it seems to me that with this proposed rule, they're not simply saying, hey, look, if stuff is happening by mistake, we're going to let it go. They really want it to be substantial prejudice and willful or in bad faith. I have to tell you, though, that when I was involved when the revisions to the federal rules occurred back in 2006, and this language was proposed back then, but the reason why it was rejected was because in 2006, the committee determined that this opens the door for a lot of bad faith. In other words, you all of a sudden you start creating, as in Rambis, all these shred days and call them routine operations, and all of a sudden you're using that as an excuse. So I don't know how far they're going to get with this proposal, but clearly what they're trying to do is stop the fishing expedition. The additional consideration for sanction will be if you irreparably deprive the party of any meaningful opportunity to defend themselves, for instance, as in the Silvestri versus General Motors case where the car was destroyed. Another thing that's considered in assessing this next part goes into the factors that are considered in assessing the party's conduct, and one of the factors will include notice that the litigation was likely and that the information would be discoverable. So is there any notice that was put out there? What efforts did you use to preserve the information? And how does the information relate proportionately to the type of litigation that's involved? So are you going to go out there and all of a sudden put all your systems on hold because there was one car accident? No, not necessarily. Are you going to put all your systems on hold over a $10,000 claim, a $10,000 breach of contract? No, not necessarily. So again, these things will be considered, so it does give us a little bit more wiggle room, but at the same time, it's going to give a lot more opportunity for gray areas that will result in more, I think, litigation and more arguments in court early in the litigation as to what things needed to have been proposed. I leave you with these committee notes. I'm not going to go into too much detail about them, but they do give you some background about what the courts were thinking about in drafting these provisions. And with that, I'll turn it over to Alon. It's been a pleasure speaking to you guys today, and I'm sorry that I have to rush to meet a client up in Century City. It's going to take me an hour and a half to get there from Orange County. But anyway, thank you so much for listening, and I'm happy to take any questions. If you guys have them, you can email them to me or provide them to BIA, and they'll forward them to me later on. Thanks, Alon.
Thanks, John. You're obviously very optimistic. Anyone who knows LA traffic, Orange County to Century City in an hour and a half, I wish you luck, man. And thank you for joining us today. I think that was a very nice description of what it means, to get it started with this stuff, what these trigger events are. You can see there are a lot of factors to consider. I think the most important thing is just that if you think it's happening and you have these and you have some of the factors that John discussed, then you are better off starting early and implementing. And that's what we're going to talk about now in the second stages. Now that you've determined there has been a triggering event or a possible triggering event, what steps should you take in order to ensure that you're protected as you go down the road of having to preserve data and do discovery? And a lot of times things don't get that far. You have a triggering event, and you start to put in place a legal hold and preservation, and then something settles or it goes away, and so the hope is that you don't have to take it all the way through the end of discovery, but you want to be prepared if indeed you are taking it that way. And also, the more diligent you are in your preparation, the better position you are with respect to the courts and with respect to the opposing party. So that said, what does it mean to implement a hold? Obviously, there's a lot of steps. There's a lot of parts. We're going to talk today at a high level as to what you want to do as an organization. And I talked about this a little bit last time, which is you really want to have a team approach. And it is true, I think, across the board with almost everything we do in corporate organizations today, but specifically with respect to legal liability, with respect to activities that potentially will lead to a lawsuit or having to pay money out. You want to make sure that the right people are involved and you're taking the right steps. And so what does that mean to work with the team? It means that you want to have a written plan in place. And so that plan should be about triggering events, but also it should be about what happens once a triggering event is indeed kind of determined to be that. So you want to make sure that once you have an understanding that you might have to go forward and preserve documents and data, that you have a protocol by which you do so, that you answer the who, what, where, why, and how. What are the systems that are implicated? Who are the people that may be involved? You want to have key players at a management level. You want to have the attorneys and litigation support, IT experts, vendors, in-house counsel, outside counsel, the RIM folks. You don't have to have a gigantic mass of people, but you want to have enough representatives from each of the different corporate domains so that as things progress, you have contacts that can help spearhead or champion that within that particular domain. You want to involve custodians. The courts more and more today, and in the first part of this series, we actually went through case law and talked about specific cases that where the courts looked to see whether the organization was involving custodians. Did you ask your employees where they maintain data? Did you notify them of their obligation to retain documents? Did you certify that they've received that notification and track it and manage it in the right way? Involving the employees, involving the custodians, I can't emphasize enough, is such an important part of this. It's a gold standard process to follow. It shows a superb amount of diligence on the organization's perspective, and also it really gets you to do smarter eDiscovery. The more you know early on, the more costs you're going to save throughout this process over time. And then, of course, you want to make sure that you have attorney guidance and supervision. You want to make sure that both in-house and outside counsel are reviewing your protocols in some frequency over the year, that there is a collection strategy in place, meaning a way to gather documents without burdening employees, but at the same time maintaining an evidentiary integrity around that. Custodian interviews are incredibly important as well. There's a lot of great ways to do that today. You used to have to go and set up a meeting and go to someone's office and sit there with a clipboard and ask them a bunch of questions. A lot of times they'd be apprehensive because they would feel that they were getting deposed in some sense. But today with web technologies and other types of technologies, it's real easy to touch employees and ask them questions and get some good answers, which then helps you strategize and focus more on the rest of your discovery process. And then, of course, you want to have reasonable scheduling. So much of some of the new proposals talk about adding preservation into the scheduling part of litigation, the discovery conferences and that kind of thing. That scheduling is key, especially if the lawyers are not in contact with the IT or the RIM folks. And say, for example, you have an attorney who knows a particular schedule, some deadlines, maybe court-imposed deadlines, or deadlines that were consented to with the opposing party, and that is not relayed in the right way to, say, the folks in IT who may have to do the data gathering, well, then you're going to have a problem because the lawyers will think they're going to have the documents ready, and maybe they haven't even yet been collected. So that notion of having scheduling and being on the same page with all the other people on this team here is very critical to a seamless process, and is going to make it so that you have a more efficient way of implementing these holds. There have been situations where, many situations, frankly, where in implementing the hold, so the trigger event is figured out. Yes, we know we may be in a situation here where we have to preserve documents, and then there is a delay in implementing the hold, both in notifying custodians as well as actually locking the data down, and that in and of itself could potentially get you to spoliations and adverse inferences. First response is critical to implementing a hold. You know, what is it that you have to do right away in order to ensure that you're going to be in compliance? Well, you want to identify custodians. Who are the people that are involved? And there's a lot of ways to do this, but primarily it's legal, in-house legal, maybe with outside counsel, talking to the business unit managers, figuring out what is this case about. And to a large extent, this information is what goes into the memo, the document that you send around to your employees and contractors, notifying them of the types of documents and the types of data that they must retain. And so that memo drafting it really is part of that process in helping you identify the right people that may be involved. You know, and there's always these discussions of, you know, who do we put on hold? How wide of a net do you cast? Do you put everybody on hold in the entire organization every time? Well, probably not. That could be overkill. It could be construed by the court. They look at how you've done it over time, and you're always putting everyone on hold, and it turns out that it's always a subset of people. Well, that's maybe a lazy man's approach, and that could come back and bite you. So you really want to think about this and think about who may be involved. Now, many times you're going to put more people on hold than you are going to actually collect. So that means that you may, say, for example, put the entire marketing department on hold, but once you do a little bit more diligence, a little bit more research, you find out maybe it's just a division within marketing, or maybe it's just several individuals within a particular department, in which case then you can adjust the scope of the hold. So you're better off always casting a little bit of a wider net without taking that lazy man's approach of just kind of casting an entire net over everything all the time. But that first part is very important, because that's really going to drive kind of the rest of the steps, at least on this initial side of things. Then, of course, you want to make sure that you notify those people who you've decided are potential custodians, and you want to make sure that you have them acknowledged. It's not enough these days to just send a notice out to people and say, hey, by the way, you must hold these things. You want to make sure that you have some kind of acknowledgement around that notice by the recipients. There's a number of ways to do that, and it's relatively easy to do these days, just to get someone to say, yes, I've received this notice, and I understand that I should be retaining these documents. And then, of course, managing that, being able to report on that is also very important. So just getting the acknowledgments and having them is, of course, important, but you may have to report on that. At some point, you may be questioned, and you want to be able to have some relatively efficient process in order to say, here's who we put on hold, here's how they've acknowledged, and here's how we're tracking that. The next part of that first response is identifying data sources. I like to call this an implicated systems exercise, where you got to look at that memo. You look at that memo, and you look at the issues in the case, and you say to yourself, what is it? What systems or what kind of data may be implicated in this? Is this a case that's going to implicate our accounting system? If not, then we don't have to worry about preserving data out of the accounting system. I can tell you that almost every case today is going to involve email, kind of the low-hanging fruit of eDiscovery. It's going to involve email. It's going to involve local resources like workstation, laptop data, home folder information, and server shares. Likely that's going to be related no matter what. But then depending upon your industry, depending upon the specific matters or issues for that matter, you may also have other systems implicated. And the great thing is to talk about them in terms of the way you describe them internally. So if you have some CRM, some customer relationship management software that you use, that you internally call it the Apex system, say for example, then you want to talk about it in those terms. You want to use the names of the systems in the same way you use them in the normal course. That's going to go very far with both your attorneys and also the court. You also want to make sure you manage automated IT activities. This is a very important part of all this. I talked about this earlier in the primer. You want to make sure that some of those automatic IT housekeeping, for example, retention schedules, backup tape activity, automatic purging of email, all of those kind of things, you want to make sure that that's managed. So you could do all this work in the top part of the process, which is identifying custodians, notifying them of their obligation, making sure you have a plan and a process. And then if you forget to suspend, say, a basic IT process that may delete email after a certain size or time, well, it's all for naught. So you really want to make sure that that third stage is ensuring that automated IT activities are covered. Now, you might say, well, there are certain IT systems that just can't be turned off. Say credit card transaction systems or real-time transactional systems, especially those that relate directly to the critical operations of the organization. Well, in that case, you want to take a reasonable approach. You want to say, what can we do to suspend some of it or parts of it, or to at least maybe export some data or lock some data down? Maybe there's nothing you can do, and that at least should be noted. The courts today are going, really have always been, but especially today under some of these issues, they're going to take a cost-benefit analysis. They're going to look at using a reasonableness standard. Could that company have done something in order to prevent data being deleted or being altered, or was that such a mission-critical system that couldn't be touched, and maybe even the data in that system can be gotten somewhere else? Maybe there's a different source, or maybe it's not incredibly pertinent to the case at hand. So you want to really think about these things before you, especially as an attorney or information governance professional, says to IT, you have to turn everything off. I'm an IT guy as well as a lawyer, as Robin mentioned, and the last thing we want to hear as IT people is that you have to just suspend everything. All of a sudden, all those things that you handle every day, that you manage, that you put a lot of effort and process and money and time into, now just because there's a legal hold, have to all of a sudden be thrown out the window. That's not the case. You want to take a reasonable approach, and that's one of the other reasons it's very important to have an IT representative on that team that puts together these processes within the organization. So they have the knowledge of the kinds of systems that can and cannot be turned off, and if so, how easily it is to do that. And then kind of the last step is data gathering, ensuring that you actually have a copy of this stuff A lot of organizations, they think of legal hold as just notifying people, maybe tracking those notifications, maybe telling IT, hey, make sure that you turn some guy's email retention off, and then that's it. That's it. You really need to take that final step and go about actually gathering the documents. Now, that doesn't have to necessarily happen right away, but it should happen relatively early in the course of things, and especially you should put thought into it. So you should think about, are there some critical custodians here who we know are going to be part of the situation? At the very least, will have to be deposed. Well, if you have a custodian who might be deposed, you're likely going to want to gather their documents right away. So there should be some processes in place. There's a lot of great solutions. Of course, BIA has one, and there are others that will allow you to lock data down, essentially create a copy and set it aside in a relatively efficient manner without spending too much time or money to do so. And that's going to be very important because at the end of the day, that's what you have. Those are the documents. If you don't have that and you are in a situation where you have to produce documents, you have to review and produce documents, and you don't have them because they have been deleted or because someone didn't realize that that just telling them to hold them didn't mean that you didn't do anything. A lot of times custodians think that legal not only notifies, but then they have some special magic thing on the back end that immediately manages the ability to not delete that stuff. That's not necessarily true. In fact, most of the cases that's not true, meaning organizations have to take affirmative steps, and usually a lot of steps or relatively complicated steps in order to gather those documents. So you want to make sure that you have that as part of your overall plan, even if you don't do it right away, that's something that will be done at the right time. So I'll talk quickly about kind of what should be in the memo, that document that you send around, who's subject to the hold, why it's issued, what should be preserved. We find that today courts are happier about legal hold memos that have plain English. So to the extent you can use plain English in describing the types of documents that you want your employees to maintain and to preserve, that will be better. You'll be better off in doing so. We're moving away from a lot of complicated legalese in, frankly, documents across the board. If you look today at a lot of contracts and software agreements, they're very much plain English. So the more you can make it plain English and the more you can make it clear, as specific as you can about what it is you want people to preserve, the better off you'll be. And then that last one, provide a contact person. It's incredible how much people do all this work and then don't have a simple line at the end that says, please contact John Smith or Sally Brown in your legal department if you have any questions. Sometimes that is more powerful than anything else you can write in the document. And again, some of these steps to successful legal hold is identify those custodians, cast a wide net but not too wide, interview the right people, make sure that you compose the legal hold in a manner that's clear, that has that plain English. Distribute the legal hold in a reliable manner. Use email, make sure that you're tracking that, make sure that you can report on that, verify that people have received it and they've read it, and have that audit trail there because that's what you're going to need for defensibility. You want to make sure that you maintain the legal hold throughout the right time frame, that you send custodians reminders. Lawsuits and legal situations don't last for a few months. They last sometimes for a few years, and so you want to make sure that an active legal hold, you're actually taking the steps to remind custodians and remind employees that they are obligated to retain documents, even though the initial hold maybe went out several years before. And then you want to be able to audit all of these steps that you take. A lot of the solutions, the commercial solutions that are out there have these audit trail mechanisms built into them, so it's a real easy way to get to that kind of compliance is just buy a commercial system. And there are a number of ones out there, including ones that we build, that are very reasonably priced and put defensibility first before anything else. And just in case you thought that costs weren't really a big factor here, in fact they drive everything. This is a judge's guide to cost-effective eDiscovery. I like to just look at the title alone. That tells you everything. Judge's Guide to Cost-Effective eDiscovery. I mean, there you go. It's kind of in a nutshell. It's everything is driven by money in business, or a lot of things are driven by money in business, and even this stuff, all the legal hold, the legal parts of it, very much about money. And here the Judge's Guide, this is by EDI, which is an institute that really does educate professionals and judges And here this talks about that it's important to have knowledgeable client personnel who are available to identify and segregate relevant documents and information. And what does that mean? That means custodians, lawyers, and IT people, information governance folks, and managers who all know what may be potentially relevant and then can take the steps to ensure that those are preserved. Attorney supervision is very important. That is part of that compliance. These are just some screenshots from our app, but the point here is that you want to make sure that the attorneys are supervising. They don't need to sit shotgun on every email that gets exported, but they definitely need to be involved in the protocol development, and that's both in-house and outside counsel, as well as the ability to kind of manage the process at a high level throughout the entire process. And in this case, I'm showing you an example of a portal that attorneys can use to see exactly what's going on when throughout the process. And then kind of the flip side of that is custodian involvement. One of the best ways to do that is just interview custodians, ask them questionnaires. We have a web-based systems you can use, but even if you literally go to every person's office and ask them a bunch of questions, that is a really great way of getting a finite scope in place and ensuring that you have all the right facts as you proceed through the case. Some of a little bit more detail around those related IT tasks, making sure that you are suspending some of those automated IT tasks, specifically around email, which is very important, and then also looking at what your backups do. You don't want to use your disaster recovery as an email repository, otherwise it will be put on suspension, constructive suspension by the courts, and so you want to ensure that you either are using a real archive system, or if you have a DR system, that you're not using it as a repository for preservation, meaning you want to have an independent process and mechanism for preserving documents for legal purposes and not just go to DR, even though it's tempting to do so because you already have it in place. And then, of course, you want to make sure that you're coordinating with all the right groups within the organizations. And if you look at the red box here, is that ultimately that this part of the preservation process is ensuring that the systems in and of themselves are not doing something to give you headaches. The people, you put a lot of effort and stock into making sure the people are doing the right things. You want to also make sure that the systems that you have in place are not essentially burdening that process or affecting it in a negative way. And so if you look at it from the custodian's point of view or the recipient's point of view, what are some of the do's and the don'ts? You want them to read and acknowledge the notice. You want to make sure that they suspend any of their own deletion strategies. Part of this is making sure that the email system, say, doesn't automatically cut you off at a certain size, but you want to also make sure that people don't do it. A lot of custodians will drag and drop emails from their inbox to their desktop into a folder and then at some point delete that because now they've done with it. You want to make sure that the people themselves, the custodian themselves, know that to the extent they do any of their own cleanup in organization, especially some of your more OCD custodians, that they know that even any of the actions that they take have to fall within that kind of suspension concept. And then you want to work with the custodians to identify locations. Courts are looking at that more and more today. They say, look, the user themselves know where they keep their data. It's a very intimate thing, especially today. Computing is just so much part of the business environment. We all have our ways of organizing our folders and our email and everything else. So it's very important today to ask custodians where they keep their data. Do you use a home computer? Do you use USB keys? Do you use an online backup? That kind of thing. That needs to be a part of the process, and it's important to ensure that custodians realize that their actions they take are very much a part of the compliance that the organization is obligated to. And then, of course, some of the don'ts. Don't delete files. Don't copy files or move files. Some of you don't know, but there's a really simple experiment. Take a USB key, plug it into your USB drive, create a document in Word or something on your desktop. Look at the metadata around that. Look at the created date, for example, and then wait a few minutes and then copy that to the USB key and then look at the created date. You'll see that the created date has changed because you've moved it to a different volume. And that's true whether you're moving into a USB key or an area of the network. So you don't want custodians to do the gathering, and that's kind of an important concept. You want the custodians to help designate what may be relevant, But you don't want them to sit there and then drag and drop a bunch of documents into a folder that you've created called the litigation folder. In fact, I tell the story a lot, which is maybe about a year and a half ago now. I was at a conference, and the head of the eDiscovery for the SEC, she was talking about one of the first things that what they do at the SEC when they receive productions is they open up the load files and they take a look to see what was the original file name. And if the original file name is the same for every document, like litigation folder 123 or something like that, they immediately kick it back for noncompliance, because one of the very important pieces of metadata that they use and that a lot of these analytics technologies and review technologies use today will rely on original file path information. So just moving or copying files around is going to affect that. Now, I know we're running out a little bit of time here, so I'm going to kind of move through this quickly. Collections, again, it's very important that dragging and dropping is not done. And ultimately, why is that garbage in, garbage out? The data is only as good as it is, and so if you have altered the metadata at the collection process, later on as your attorneys are reviewing it and they're relying on dates or metadata that may be wrong, there could be a lot of problems, and sometimes you don't have the ability to go back to the well. You've already, the damage is already done. Where are the areas you need to go to? I talked a little bit about the implicated system exercise. So you have the common data sources, but you also have some new data sources as well, especially today with the cloud, handhelds, cloud-based applications, enterprise applications. You really want to think of what is this case about, and are these systems implicated? And then you want to make sure you select the right approach. Homegrown processes were great 5 to 10 years ago, but today there's enough commercial software that's reasonably priced, that's reasonably easy to implement, where at the very least you should be looking at these things. And obviously, we build this stuff and we sell it, so we always want you to look at commercial systems as a vendor in the space. But I mean, the reality is the maturity of the industry has gotten to a point where you really shouldn't be home growing a lot of this stuff. There's always going to be some amount of home growing you want to do. Maybe you have a proprietary system, or you have some kind of unique system that you don't have to go to all the time. You don't want to necessarily buy commercial software for that. But the low-hanging fruit, email preservation, notification of employees, those kind of things, there's a lot of good tools out there, and I urge you to take a look at them before you start to build your own system in-house. And then how long does legal hold last? That's a really interesting question. You can do an entire webinar just around that question. But ultimately, settlement, consent, you keep in mind that holds, you're better off keeping things on hold for as long as you can. But there's a fine line there, because you don't want to hold things past when you need to, because especially as an information governance professional or as a RIM person, one of the things we're always trying to do in information governance is ensure that we're only maintaining what we need for kind of the corporate side or compliance side. And so the same is true with legal holds. I have experience with some companies that will hold things for years and years and years, even afterwards, because they're so afraid to delete something because it may come out later. So there's steps you can take, and there's definitely a process. You should bring lawyers involved in that process in order to determine what is it that we can get rid of and when is the time to do so. And I must mention exiting employees. That sometimes we forget. But a lot of times the issues that we see as eDiscovery experts are around data that is no longer around because the employee is no longer around. And so we have there's a lot that you can do around that. We have some clients that have exiting employee processes and protocols whereby anyone of a manager level or above or whatever it may be, when they leave, their assets are sequestered, the data is dumped, and then they're held for some period of time until the legal department has an ability to determine whether they're actually on hold or not. So you really want to make sure that you're thinking about exiting employees and how is that going to affect any current or possibly future litigation or legal hold. So with that, with 2 or 3 minutes left, I'll open it up for questions. I know some of you have been asking questions kind of all along. So Robin, if there are any that you think are appropriate to be asked in the last few minutes, we could do that. And like we always say, if you have any other questions or you want to get in a little bit more of a deep dive, please do so via email, and we'll give you as much time as you'd like in ensuring that you have the right clarity around some of this stuff.
Alon, we've got some excellent questions. The first one asks, I know this is important, but how do I get my executives to buy into this?
Yeah, executive buy-in and management buy-in is so critical, and Some of it may be fear, right? Hey, show them some of that case law that John talked about, and look at what happens when we don't do these things right. At the end of the day, executives and management, the buck stops with them. And today especially, they could even be personally liable, not necessarily from an actual money perspective, but definitely from a job perspective. You don't really want to be the guy who said, I don't care about this stuff, or I don't really want to hear about it. And it turns out that the company now has to pay sanctions or something, and you were the executive in charge of ensuring that's correct. So GCs especially have a big part of their role is ensuring that they go to the CEO, they go to CFO, they go to all the right people, the executive committee, the board, and really get that buy-in. And I think you'll find that most executives, they get this stuff. They understand the liability and risk issues. And so if you just present it to them in a rational manner and show them some war stories, I think that will go a long way. But frankly, that's one of the most important things, is to get that executive or management buy-in. And that even comes down to the custodian level. If you have custodians like, just another legal hold from those attorneys, it's very important that the managers are emphasizing that in their quarterly meetings or in their staff meetings. Hey guys, we may be involved in a lawsuit. It's very important that you retain documents. That really should come not only from the executive, but also just even from middle management.
Alon, I have a follow-on to that question, asking if that same advice applies to smaller companies. The person says, sure, large companies have committees and budgets, but I work with a smaller company that just doesn't work like that. What's your advice?
My advice is that a committee can be two people. It can be the in-house lawyer and the owner. We have companies that are under $5 million in revenue that use our legal hold software because they may have 2 or 3 cases a year. So what I would say is that it's the same process. It's just less people and maybe less details. And so maybe it's just the IT guy and the owner of the business, or an IT person, a person from legal, and a manager of a business unit that get together in order to ensure that people are preserving. So it doesn't necessarily, this is not, by all means, this is not for large corporations only. In fact, more and more we're finding the small and medium-sized guys are starting to get hit with this stuff, especially because for years it was the large guys that had all these things in place, and the courts would kind of turn a blind eye or sometimes to a smaller company not doing these things. But again, in today's mature eDiscovery environment, and because the courts are getting much more savvy, we're looking at proposed rule changes here. It's very important regardless of what size. I have a lot of friends that are small business owners, and they roll their eyes when I start talking about legal holds. They're like, yeah, you're in that business. But I just had a friend of mine. He has a small company. They have 6 employees, and he was involved in a lawsuit. And luckily I was his friend. I was able to kind of tell him what he has to do, but he would have never known it. And even his attorney, who's kind of a solo practitioner attorney, didn't think it was important. He said, yeah, that's more for the big boys. But frankly, whether you're big, small, or medium, there are steps you can take without breaking the bank, even if it's just a matter of ensuring that you're not deleting email. These are obligations that cut across every size organization.
Okay. Well, we're out of time for today, and I would like to thank our speakers, John Azazan, Alon, Israely, for your valuable time. And I would love to thank everyone who attended today's Knowledge Leadership webinar for your valuable time. Next month, on the 19th of September, Brian Schrader, who is president of BIA, will be presenting an all-ethics presentation on the legal ethics of legal hold. So stay tuned for more information about that. And we'd like to ask you to take just a moment to complete the short survey as you exit the webinar today. Again, thank you for attending, and thank you, Alon.
Thank you, Robin. And just to remind everyone, if you have any other questions, please send an email to education@biaprotect.com or to me directly or to John directly, and we are happy to take as much time as we need to in order to give you an answer and more clarity around any of these topics. So thank you for everyone for joining us today.